TV licensing letters might amount to harassment, and in this video I'm going to explain why. With the help of this letter here, sent to me by one kind viewer who has received dozens of these over the years. I'll come back to the letter and why I think these kind of letters might collectively amount to harassment in a moment. But first of all, if you're new to me, I'm a barrister of England and Wales, and I help you to understand law on this channel. I'd be very grateful if you hit that subscribe button and subscribe if you find this video useful. So to tell you why I think this is the case, or could be the case, I'll assist you with a bit of a story. A real story and a real case that went to court, even to appeal, surprisingly enough, to many lawyers, but nonetheless it went to the Court of Appeal. This was the case of Worthington and another against the Metropolitan Housing Trust in 2018. But the story obviously spans a few years before that, so here is that story. This is the story of Mr. Worthington and Miss Parkin. These, the claimants in this action for harassment, were both assured tenants of the Housing Trust since 1997 and the year 2000, respectively. For quite some time, they'd been worried about antisocial behaviour on the trust estate. With the permission of the Housing Trust, they installed CCTV equipment. Well, Miss Parkin did, anyway, at her home for the purposes of her own security. Mr. Worthington, whilst also concerned about this, established a residents group. He appointed himself the chairman, and they were together to watch over the antisocial behaviour in this area. He even created a website for the group and published the evidence to this website that he considered to be unacceptable behaviour. All of which you might think reasonable if there's a lot of antisocial behaviour in the area and they want to highlight it, bring attention to it, and ultimately stamp it out. However, this is where the troubles began, because neighbours began getting concerned over this CCTV activity. They made arguments that the CCTV was infringing on people's privacy rights and argued that Mr. Worthington had taken inappropriate photos of other residents, including children, and all of these neighbours then collectively submitted complaints to the Housing Trust. Then, in 2007, senior employees of the Housing Trust went to meet the claimants to discuss these concerns. At the meetings, the claimants outlined their concerns about the antisocial behaviour, the steps they were taking to overcome it, and ultimately why they'd installed the CCTV. In September that year, a Mr. Kotecha, who was the estate manager for the Housing Trust, visited Miss Parkin at her home and told her to remove the CCTV equipment. But she refused to do so and explained that she'd installed the CCTV for her own safety because of the antisocial behaviour in the area. Over the coming months, Mr. Kotecha was then increasingly pressurising Miss Parkin to remove the CCTV. He even called the police to her home and produced a petition which was apparently signed by 80 individuals, 80, which was an important point that came back later, as noted at paragraph 27 of the appeal judgment, which said, in fact, only a small proportion of the individuals who signed the petition were residents, and the judge, in the original case, found that it had been produced on a Sunday and probably at one of the junior football sessions. Mr. Kotecha also provided 7 statements which, again, purportedly prepared by residents, which contained complaints that they were using CCTV allegedly in breach of their privacy. And it's important to point out at this point that none of this activity had any real substance when the case went to court. The case going to court, of course, was a claim for harassment by the Housing Trust against these 2 individuals. But matters then only got worse. Mr. Kotecha instructed solicitors for the defendant Housing Trust, who in turn wrote letters to both Miss Parkin and Mr. Worthington, accusing Miss Parkin of breaching the privacy rights of her neighbours and accusing Mr. Worthington of using CCTV at his address. Both of these allegations, as it turns out, were false. Not only did Mr. Worthington not have CCTV at his property, but the judge in the first case found that Miss Parkin had only used the CCTV for personal security and not to invade privacy of any other neighbours. Matters continued to escalate month on month. The following month, the Housing Trust threatened to evict both of the claimants unless they stopped the alleged misuse of CCTV, and each of the letters repeating inaccuracies that were contained within the original letters. A month later, they wrote again threatening legal proceedings, but this time the claimants responded to denial of the allegations and any implications of wrongdoing, but the Housing Trust persisted. In January of 2008, solicitors for the Housing Trust wrote to Miss Parkin to say that they were going to apply for an injunction to enforce the terms of the tenancy agreement, unless she removed the CCTV equipment within 7 days. But despite the fact that Miss Parkin did not remove the CCTV equipment, the Housing Trust did not apply for an injunction as they'd threatened to do. But Miss Parkin wasn't told about this until much later in the year. Similarly, Mr. Worthington was also sent a threat of legal proceedings in that same January of 2008, and again telling him that legal proceedings were in progress, which included an application for an injunction. But none of that was actually quite true. There were no live legal proceedings at that stage, and indeed none were submitted after that. So then the claimants got fed up of these legal threats and filed a claim in harassment by the Housing Trust. In that first case, the judge found that the Housing Trust's conduct did indeed amount to harassment. And this was because they'd issued serious threats without actually taking any basic steps to check that they had any basis in fact. The judge concluded that the claimants were subject to improper threats of legal action, the threat of losing their home, and all of which created a particular anxiety. So why indeed does this case potentially have anything to do with TV licensing? Well, one of you guys, very kindly, you'll know who you are, sent me dozens of letters that you received from TV licensing over the years, of which this letter is one. Now, this letter of one of many strikes me as very interesting because most of these letters are threatening in nature in one sense or another. Most of them either directly threatening or alluding to the threat of prosecution for illegally watching TV, which they are happy to point out is a criminal offence. And many of these letters provide a specific date within a relatively short time frame. So this letter opens with a calendar snapshot with the date of the 10th of August circled and says, "We're giving you 10 days to get correctly licensed." Now, that presupposes that the address is not correctly licensed, which of course it might be. Because without divulging any information about the viewer that sent this in, if they don't watch or record live TV and they don't watch BBC programs on iPlayer and they've never installed any equipment for that purpose, then they don't need a TV license. In which case, not having a license would be a correctly licensed address. That being the case, the letter just opens that there is no record of a TV license at this address. But it doesn't follow that the address is not correctly licensed just because there is no record of a license at that address. Although I am impressed that the letter then correctly sets out what the law requires, albeit in a threatening tone. It says, "This means you are breaking the law if you are watching or recording live programs on any channel, or downloading or watching BBC programs on iPlayer on any device." That's the best description of what requires a license that I've seen in a great many of these letters. However, the overall threatening nature of this letter and the specificity of the date of the 10th of August. Now, as I understand it, there has never been a visit, the 10th or otherwise, to this address. We will not visit you for 10 days, but you must get correctly licensed. We know how difficult it is to pay bills at the moment. That's why we're giving you until the 10th of August to get correctly licensed. Our investigation of your address has been put on hold and we will not send an enforcement agent during this time. Call us by the 10th. One of our specialist advisors will help you check. Now, the remainder of this letter doesn't say that there'll be a visit to the address, although many of them do. This letter simply threatens a full investigation if the recipient of the letter decides to do nothing. But doing nothing is not a criminal offence. Because if the address is correctly licensed by not having a license, i.e. it doesn't need a license because, for example, they just don't watch or record live TV, or it's a second home in which they don't have a TV and don't watch TV, and the only time they do is on a device which is battery powered, which comes under their home license. For example, there are a great many reasons why an address might be correctly licensed, for example, covered by a license at another address and not need a license at that address. But doing nothing is not a criminal offence. But this letter says that if you decide to do nothing, there will be a full investigation. And these letters follow on and on and on. Month after month, there are dozens of these letters to this address. Now, yes, on the one hand, you can file the form to say, I don't need a license. And in many cases, in a lot of cases that I've heard of, this is perfectly fine and people don't get any more letters. But in some cases, these letters persist. But to specify a date, as this one does here, and many other letters that I'll come to and cover in other videos, these are very specific threats that might cause someone severe anxiety. And it is this anxiety that I was referring to from the other case of Worthington and Metropolitan Housing Trust, where the judge found that it went beyond just being unreasonable conduct to that which is oppressive and unacceptable, which is the threshold for harassment. So on the one hand, you could look at letters such as these coming from TV licensing as being unattractive and even unreasonable. But how many letters and what wording is required to cross the threshold for conduct of sending out these letters, which then becomes oppressive and unacceptable? And one of the tests for determining whether it's oppressive and unacceptable is the level of anxiety that it might cause. And as the judge said in this particular case, with reference to the Protection from Harassment Act, the judge said, to cross the boundary from the regrettable and unacceptable, the gravity of misconduct must be of an order which would sustain criminal liability. So a fairly high test, but a test nonetheless that would assess the level of anxiety that an individual would feel. And again, referring to the case of Worthington and the words of the judge, these letters might be seen as a campaign of harassment. The judge said, taking a typical case of stalking or malicious phone calls, when a defendant walks past a claimant's door or calls the telephone but puts down the phone without speaking, a single act by itself is neutral, or might be. But if an act is repeated on a number of occasions, the course of conduct might well amount to harassment. That conclusion can only be arrived at by looking at the individual acts complained of as a whole. The course of conduct cannot be reduced to or deconstructed into an individual act taken one by one. So it's with a course of communications, such as letters, including the first letter, might be innocent by itself and might even cause no alarm, or at most slight unease. However, in conclusion, the judge said, in light of the subsequent letters, the first letter might also be seen as being part of that campaign of harassment. And taking one other letter by way of example, which illustrates that this campaign of letters has been going on for, at the very least, 4 years, this early one from 2018 says, please get in touch to avoid further action. Now, further action presumably would be legal action because it's threatening an investigation, it's threatening a prosecution if someone at the address is indeed watching TV illegally, which presently is a criminal offence. However, the mere fact that this was in 2018, 4 years before this one, and clearly nothing has happened since then because the campaign of letters has continued. This is 4 years on from this letter threatening further action. Now, any one individual might well feel the threat and intimidation of legal proceedings from that date. But in this Worthington case, each of those claimants were awarded more than £4,000, just over 4 and almost 5, respectively. So the claim in harassment succeeded on the basis that the continued threat of legal proceedings, which had no factual basis, amounted to harassment. Now, in the case of these letters, I am assured that the address does not need a license. It is unlicensed, but it is properly licensed because it doesn't need one But in my view, the dozens and dozens of letters spanning several years threatening further action and prosecutions and investigations again and again and again, there is a possibility that a judge would find that this is harassment, notwithstanding that TV licensing has a statutory duty to ensure every address is licensed and so on. In my view, that doesn't pave the way for several years of letters threatening action when none is taken. So those are just my views. They are just my views. It is not legal advice. It is not the law as it stands. The law as it stands says you need a TV license if you watch or record live TV or you watch BBC programs on iPlayer. And this includes any live TV program from anywhere in the world on any device, except for those that are not a television program service, such as my live streams on YouTube or many other live streams on YouTube are not live TV for the purposes of the legislation. But I hope you found that interesting. Please do like the video and subscribe. I appreciate that. It helps my channel grow. And as always, thank you for watching. Have a great Saturday.